Islam, peace and love, peace, love, and energy. I am Sade Renee L, all rights reserved, and I'm back at it again with another video. And today I'm actually going to be doing a video on my federal lawsuit. But before I get started, I want to state notice to principal is notice to agent. And 8th Judicial Family Court, Las Vegas, continues to act in fraud as they have delayed filing my paperwork, including my second appeals, and additional writ of quo warranto and default judgment that I have sent. I have all the proof, USPS. Again, I'll actually go into depths about that more in a later video, but for now, just giving notice to the public regards to my current federal lawsuit, my second amended complaint against all conspirators who are parties of the matters of violating my inalienable rights. Also want to take notice that Sarah Da Lue of Las Vegas, who works for Desert Pines High School, Las Vegas, acting as the foster mom, and Donella Rowe acting as the prosecutor for the district attorney, they'll be added to the suit against my civil rights as well. And per usual, please like, share, subscribe. Go ahead and leave a comment. Free baby Ashe. Ashe will be home soon, so mote it be. So I'm going to read just straight through it. And it reads as follows. And again, this is public record, so anybody has access to this, but just going to share with you guys my public record so you'll have easier access to it. And it states as follows once again. The right to family association is sheltered against the government's unwarranted usurpation, disregard, or disrespect. Amended complaint. Petitioner Sade Renee L, that's me, all rights reserved, enters an amended complaint against defendants Stephanie Ann Charter, Adriana Recon White, Belinda T. Harris, Stephen B. Wolfson, Stephanie Richer, Beth Rosenblum, Nick Pettis, Paya Patel, 8th Judicial Family Court Incorporation, Nicholas Eason, Michelle Polino, Shalonda Adams, Tisha Evans, Didia Garcia, Child Family Services Las Vegas Incorporation, acting as Sheriff Joe Lombardo, and acting as Policy Enforcers Officer S. Guerrero, number 18286, and Pete Anderson, number 16266, in state of Nevada as follows. Introduction. Defendants Stephanie Ann Charter, Adriana Recon White, Belinda T. Harris, Stephanie Richer, Nick Pettis, Paya Patel, Beth Rosenblum, all conspired together knowingly and willfully broke their oath to the U.S. Constitution for financial gain, and as a result of the policies and customs of the 8th Judicial Family Court, Las Vegas. Petitioner Sade Renee L. affirms that defendants S. Guerrero and Pete Anderson knowingly and willingly made an unreasonable search and seizure of her persons, assaulted, battered, raped, and falsely imprisoned her by forcing her to remove herself from her automobile, physically restraining her without cause, sexually assaulting her by removing her clothes, and kidnapping her without cause. Petitioner affirms that these constitutional violations were committed as a result of the policies and customs of the Las Vegas Metropolitan Police Department, which Sheriff Joe Lombardo is responsible for making the law of the land and being adhered to, and that unalienable rights are not being violated. All right, that's page 1. Let's go to page 2. And it's only 11 pages, so we should be by this fast. Number 3. Social and caseworkers' duties include protecting the constitutional rights of the child and parents. Defendants Nicholas Eason, Michelle Polino, Tisha Evans, Shalonda Adams, and Didia Garcia intentionally inflicted pain and emotional distress out of discrimination, under color of law, and following Child Family Services policies and procedures which federal legislation requires agencies, whether it's county or state government, to provide training to their social workers regarding the law as it relates to the work that they are doing in child investigations. Jurisdiction and venue. This court has jurisdiction able to review, hear, and determine matters pursuant to the Constitution of the United States, 42 U.S.C. 1983, 28 U.S.C. 1331, and 1343, 42 U.S.C. 1985. Constitution of the United States, 4th Amendment and 14th Amendment, and the Constitution of the State of Nevada, Article 1, Section 1, 5, 17, 18, and 20. Federal court agents have constitutional obligations and oaths they're either sworn or affirmed to by Article 15, Section 2, Nevada Constitution. Let me drink some water real fast. Venue lies in the United States District Court, District of Nevada, because all events giving rise occurred at Las Vegas, Nevada. And 28 USC 1391B hyphenated 2. Petition and party. Petitioner Sade Renee L. is a foreign national. She is a loving mother and a personal trainer by trade. She has worked in office management and has coached children's sports for over, let's go to page 3, 10 years. She is very respected and honored for the years of volunteering to feed the homeless and take care of the elderly. That's a fact. Background. On June 28, 2020, around 6:28 p.m. at Las Vegas, petitioner Sade Renee L. and her offspring Ashe Divine L. sat in her parked automobile at a major shopping lot, charging her phone to obtain GPS directions to travel home. Being parked for approximately 6 minutes, she was aggressively approached by policy enforcer Escarrera, number 18286, and Pete Anderson, number 16266. Both defendants began to yell and threaten Sade Renee L. to show authority and aggression. Being vulnerable and alone at the time with a baby, petitioners began to feel very nervous and scared for her life. Both policy enforcers then began violating her rights to privacy, forcing her out of her conveyance as Escarrera started to reach at both sides of his hips, clearly insinuating he had several weapons and that he was ready to use it. With no evidence or cause, petitioner was sexually manhandled, groped, and raped as both policy enforcers began filling on her breasts and legs as they took off her clothes. See Exhibit A, Property Report LVMP. I'll pause right there because they actually did completely strip me, and I do have proof of that via my property report because when I went in, I didn't have any clothes. So when I left, I didn't have, they had to give me shoes to go, they had to give me pants to leave with and a shirt because these policy enforcers raped me. I'll continue. As petitioner was unlawfully placed in cuffs by Escarrera number 18286, she witnessed number 16266 open the back door of her automobile and remove the diaper from Sade Renee L's newborn baby. As petitioner cried out in anger and shock, she was beaten and kidnapped. Petitioner did not violate any traffic laws whatsoever. She was not illegally parked and did not engage in any unlawful conduct while in the parking lot. Defendants falsified the police report and added child endangerment out of retaliation. Both defendants are liable for setting in motion a series of acts by others, which both defendants knew or reasonably should have known would cause others. All right, let me go to the next page. Inflict a constitutional injury. Both defendants in writing swore under affirmation petitioner was Black. And you know I'm not Black, y'all. You know I'm not. Petitioner does not fall under Christian Black codes of 1924. According to Moreau versus Pape, policy enforcers can be sued as individuals and be liable under 42 USC 1983. Escarrera number 18286 and Pete Anderson number 16266 both knowingly and willfully interfered with the parent-child relationship and violated petitioner's unalienable rights under color of law / color of state law. Defendants trespassed and violated 42 USC 1985-1983 as they deliberately obstructed justice. Nicholas Eason. Let's talk about him. Nicholas Eason was assigned as a caseworker for Child Family Services Las Vegas. At the time of seizure, he did not lawfully have in his possession specific and articulable facts that to show the child is in immediate danger of suffering severe bodily injury or death, and that he could explore lesser intrusive alternative means of averting that specific injury. Sade Renee L. spoke to Eason on the phone around July 1st, 2020, demanding her baby back and confirming there's no contract. The baby was born at home and was born sovereign, as natural mother never signed slash autographed a U.S. human trafficking birth certificate. The baby is protected by the treaty and the rights of a child. She explained to him how great of a mother she is and how her offspring was well protected, loved, and properly taken care of. Ashe, petitioner's heir, has never had any medical conditions, no allergies, very happy, and was advancing in development for her age. A few hours later, defendant abruptly, without invitation, knocked on petitioner's door where she domiciled. Out of duress, she was forced to let him in. Nicholas Eason verified the house was very clean, neat, and a great amount of food and toys. And the home was properly safe and organized. After petitioner refused his advances out of spite and abuse of power, Eason intentionally began to demolish petitioner's family by way of genocide and violate, hold on, I can't really see, but I'm just going to go to the next page. Deliberately ignoring several, hold on, oh yeah, and violate her rights, deliberately ignoring several affidavits and emails from petitioner demanding her offspring slash property back. Sade Renee L. specifically stated that he is in violation of the U.S. Constitution and that he is acting under color of law, which he would be sued for in his individual and professional capacity. Petitioner never waived her rights and her property child heir slash, well, no, I said it, and her property slash child slash heir, excuse me, Ashe Divine L, refuse involuntary servitude and are both protected by the rights of indigenous children. Treaty of Peace and Friendship of 1836, as they both legally identify as Moorish Americans. Defendant is receiving illegal funds per Title 4E in violation of Social Security Act 1935, 1101 6D. Nicholas Eason knowingly acted with egregious conduct while violating 42 USC 1983. Let me stop there because I can't even read this because it's like on my mind. I'm like, I gotta like add on. So Nicholas Eason actually came to my home. When he came to my home unabruptly, um, I had just gotten out the shower and I had told him like, hey, I had just got out the shower, like it's not the right time. But he like super insisted that he came in. And of course, you know, I'm just saying, I'm just trying to get my baby back. And my home is always clean. Again, I have like a little bit of OCD, but not in like a horrible way, like just in a very clean way. So he even admitted and he even put on file and even sworn affidavits that my home was very clean. There was a numerous amount of toys, food. He checked all my refrigerators, all my cabinets, like it was no alcohol, no nothing. He even stated on record, like it was like super clean. And then from there, he started like trying to have small talk with me. And, you know, I'm just like trying to focus on my baby type of conversation. And it got kind of awkward. And then he gave me his business card and then like told me I can call him anytime. And like he started talking to me and is like flirting with me. And it was very uncomfortable. And I told him that I felt uncomfortable. And he was like calling me like a crazy ex-boyfriend when I was traveling. And I told him, hey, I'm traveling. I can't talk right now. I'm going to call you back. I hung up with him. He called me right back. I'm like, hey, and my Bluetooth is like automatically picking it up. And I'm like, hey, I'm traveling right now. I'll call you back. I literally was going to call him back in 10 minutes. It was, you know, about my child. I would hope so. But the fact that he kept calling me back, calling me back, calling me back, like back to back. And I kept telling him, I'm going to call you back. Like, just give me 10 minutes to get home. I am traveling. I don't want to talk in traveling. That's a distraction. And again, he just was very aggressive, very flirtatious. And so I had even wrote his supervisor in regards to, I felt uncomfortable and like it was sexually harassing at the time, telling me I can call him any time of night. Like, I don't need to call you any time of night. Like, that's not professional whatsoever, and it's unnecessary. I just want my baby back, period, point blank. So I wrote an affidavit. I filed it as well. So these are also attached with the federal suit. I'd have to go over almost 60 to 70 attachments. But again, I'm just going over the amended complaint for now. But I just wanted to add that on because I couldn't even read properly without like getting that out the way. Let me drink some water real fast. All right, where I'm at. Eason continued to act Eason continued to act unprofessional in his professional practice, violating policies for his own personal gain, money incentives, and due to being vindictive and malicious behavior towards natural mother and proper persona for retaliation purposes for non-cooperation. Michelle Polino was transferred a few weeks later as a permanent caseworker and pretty much imitated his co-workers' incompetence to state law, U.S. Constitution, common law, and parental rights. Petitioner then reached out via phone and email to Supervisor Shalonda Adams and Tisha Evans. Elle explained to Adams and Evans her nationality status, how they are violating her birthright / parental rights, while again demanding the immediate cease and desist and return of her baby. Affidavits also sent, please see attachments. With no empathy, regard, concern, or care, petitioner's visitations were cut shorter with her. And I'm gonna go down to these footnotes really fast. Just a side note, a state cannot refuse to give foreign nationals their treaty rights because of fear that valid international agreements may possibly not work completely to the satisfaction of state authorities. Ooh, excuse me, I had to burp. Under the Supremacy Clause of the United States Constitution, Article 6, Clause 2, state policies must give way to overriding federal treaties and conflicting arrangements. Also, nothing in this act shall be construed as authorizing any federal official agent, or representative in carrying out any of the provisions of this act to take charge any child over the parents of such child, or the person standing in loco parentis to such child. So again, violation after violation. Let's go to page 6. Daughter and CFS workers began to alienate the child from the mother. So again, when I started making more complaints, I started letting them know how much they're violating my rights. They started cutting out our visits. They started just immediately canceling them. I would like show up to my visit and Ashe would not be there. They wouldn't give me any type of notification whatsoever. And it would take me 2 hours to travel there and 2 hours back. A government agent has the duty to intercede when his or her fellow agents violate a person's constitutional rights. See Cunningham versus Gates. So that's a fact. So all of those, like the supervisor, she had the authority to say, hey, all right, he's doing wrong, release the child, or vice versa. Anyone, they all had the duty, the responsibility. If they saw another one of their fellow agencies violating a person's constitutional right, they had the duty to intercede. All 3 defendants, Michelle Polino, Tisha Evans, and Shalana Adams, had opportunity to cure and intervene the unlawful acts of Nicholas Eason and or each other. Polino, Evans, and Adams failed to investigate and all conspired together, signing under penalty and perjury as a complaining witness, which does not entitle them from immunity. In the area of child abuse, social workers are constrained by the substantive and procedural guarantees of the Constitution. Suspected child abuse does not permit, I repeat, Suspected child abuse does not permit a social worker to ignore a parent's constitutional right. See Wallace versus Spencer, Ninth Circuit, 2000. During a video call, Ashe was sleeping on foster care man while he had on shorts. This was before Sarah. And a print, I'll repeat, a print was bulging out of his pant, and he had Ashe sitting on his lap. And he was caressing her back as she sat on his lap. So she's sitting on his lap. He has a bulge out of his pant, and he's caressing her back like she's a cat or a dog. As she sleep, keep in mind. I was livid. Petitioner was furious and immediately called all the defendants. All three of them. All three defendants did not care. They did not care that I had witnessed my daughter being raped on camera by a foster dad, quote unquote. I then called acting as sheriff and I sent the attachment with the amended complaint. Again, I'm not going over that now, but I also called the sheriff in regards to that. We'll go into, how he became a party of the matter as well, because he had opportunity to cure. Evans, Adams, Polino have neglected with intent to have Ashe molested, as she was stolen and kidnapped from her natural mother and was forced to get her diapers changed and baths around several strangers under CFS care. Again, I had several family members reach out to get Ashe. They made several excuses on why they could not get Ashe. Their duty was to reunite families together, not separate them, not have my daughter raped by other people, changing her daughter, caressing them while they have hard-ons. And then when I tell you about this, I have firsthand witness that this happened. And on top of that, it was on a Zoom call, so it should have been recorded. They should have evidence of it as well. You saw this happening. Defendants acted together to violate petitioners' unalienable rights, violating the 4th and 14th Amendment and in violation of 42 U.S.C. 1983. Defendants are all receiving illegal funds per Title 4E in violation of Social Security Act 1935, 110160. Page 7. Didia Garcia is an agent for the Visitation Center of Child Family Services, Las Vegas. October 13, 2021, during petitioner's forced visits out of duress and coercion, Didia Garcia sexually assaulted Sade Renee L. as she was unlawfully asked in the public visitation room to remove her bra. Yes, this worker asked me to remove my bra in the main area of the visitation room with several parents and children around them. Last time I checked, that's indecent exposure. After petitioner refused, clearly, Didia Garcia's advances, out of retaliation, Didia Garcia knowingly and willingly ripped the child heir property from petitioner's arm and locked Ashe in a room. This is crazy, y'all, and this literally happened. And the cold part about it is I have it all on camera. I had a video recorder. So this is all on camera. And I will be showing that video. And that's the last time I saw my daughter. The last time I saw my heir was Didia Garcia ripping her out my hands because I refused to take off my bra. See attachment 10, affidavit of fact, complaint filed 10/21/2020. Yes, I did call the policy enforcers. The Las Vegas Metro policy enforcers were called and an incident report was given to the petitioner. Again, I have proof of this. Please see attachment 10A, Henderson Police Department case information. Petitioner made a formal complaint to Supervisor Tisha Evans for review, which was never responded. And I also stated on my affidavit that's admission by acquiescence. See attachment 10B, filed with Steve Gerson, clerk of court for the 8th Judicial Family Court, acting as. Didia Garcia maliciously, willfully, without care or concern, violated the 4th and 14th Amendments and is in violation of 42 USC 1983. Didia Garcia knowingly broke her own company policies as she denied natural mother bringing toys and clothes to the forced visits. So she also had a problem with me bringing toys and clothes to my baby. And it clearly upstaged everyone in the visiting center because you could clearly see that those mothers probably needed CFS's help, and I was the only one, and they were looking at me like, why are we there type of situation? Because I brought her brand new toys every week, brand new clothes, shoes, jackets, you name it. And then she, all of a sudden, one day I go to the visitation center. She's like, oh, you can't bring these toys in. Like, why? Oh, it's a policy. Show me. Oh, we can't show you. So it's no policy. You're just making things up as you go. Again, defendant began making up her own rules of visitations out of discrimination, color of law, and color of state law. Defendant Adriana Recon White was assigned as the magistrate July 2020. Petitioner Sade Renee Ells denied due process as the defendant White committed treason. Ignorance of the law is no excuse. Petitioner had her first hearing in July 2020, and during her special appearance, she stated on record that 8th Judicial Family Court does not have jurisdiction over free living beings, and she does not waive any of her unalienable rights. Petitioner White was given the opportunity to cure by proving on record jurisdiction as required by Article 3, Section 1 and 2 of the Constitution for the United States of North America. Defendant has the duty to apply strict scrutiny as a fundamental rule to analysis. During trial, 2 witnesses took the stand, and both testimonies did not match. I'll pause right there because again, during our initial trial, they had the policy enforcer took stand, and some man that I've never seen a day in my life came up with this imaginary story. I don't see how it happened in 6 minutes. I've never seen this man a day in my life. And the thing is, again, the man that I've never seen a day in my life had this outrageous story, and it matched nothing of what the policy enforcer said. I asked him, what did I have on? One said I had on shorts. One said I had on pants. I asked, what were we doing? One said I was awake. One said I was asleep. Like, wait, what? Like the testimony did not even match whatsoever. And they had no proof whatsoever, like no scars of abuse, no witness testimony saying, hey, they saw me abuse the baby or neglect the baby. Nothing whatsoever. Nothing. Defendant Adriana Recon White stated on record and confirmed. She literally confirmed this on record as she was making her final quote unquote judgment. She stated on record, okay? She said, even though both witness testimony does not match, she still proceeded to violate defendant's God-given rights, my God-given rights as a mother, and did not dismiss the case and just move forward and didn't give me back my baby. White also refused my due process by denying petitioner to bring my witnesses up to testify on stand, stating she had to end court early due to personal reasons. So I had 2 witnesses come out on my behalf to, state on record how great of a mother is, how I've never abused my child, how she's never been neglected, how she's well taken care of. And White did not allow them to come up. They flew out of state to come up as well. She did not allow them to come up because she had to end court early because she said she had something to do. So with her having something to do, my witnesses never took the stand. Their witnesses was able to take the stand who had testimonies that did not match, but my witnesses weren't able to take the stand. Doesn't look like due process to me, right? Okay, let's continue. So I'll repeat it. White also refused due process by denying petitioner to bring her witnesses to testify on stand, stating she had to end court early due to personal reasons. White has committed treason as she is aware of petitioner being protected by the Treaty of Peace and Friendship of 1838 between the Moroccan Empire and the United States. Say 8-6. Defendant has practiced malicious prosecution and voluntary servitude and is currently continuing seizure, violating the Declaration of 1959, Rights of a Child, Principle 3 and 9. She has knowingly broken federal policy, FP Rule 60B. Judges must maintain a high standard of judicial performance with a particular emphasis upon conducting litigation with scrupulous fairness and impartiality. Petitioner stated on record to White that for the kidnapping of her child, it'll be $100,000 a day in fines. White responded she'll bring her checkbook. Please see exhibit. Again, I cannot make this up. This is on record. She said, we had a lady back there typing, okay? This is on record. I told White, I said, as she said, after she said on record, even though both witness doesn't, the testimony does not match up, I'm going to continue with the seizure of the child. I told her it's going to be 100,000 a day in fines for the kidnapping of my child. I told her for the record, it's going to be $100,000 a day for the kidnapping. She said next time we come to court, she's going to bring her checkbook, and she left on record. Okay. Belinda T. Harris was assigned to the case and was immediately put on notice by petitioner Sade Renee L., demanding her child back and the opportunity to cure and uphold her oath to protect the people. Harris has practiced law from the bench and is also committing treason and crimes to humanity. L filed with the clerk of court affidavit denying as natural mother all vaccinations, okay, because they were trying to vaccinate my child, which they fraudulently did. Harris violated natural rights and intentionally ordered the child to be vaccinated for money incentives. You know, of course, they get funds for that. The interest of the parents in the care, custody, and control of their children is perhaps, I'm gonna read that again. The interest of the parents in the care, custody, and control of their children is perhaps the oldest fundamental liberty interest. Okay. If Harris was acting in law, she would have honorably removed and recused herself from the case. Harris is not a family court judge, magistrate, and is not trained in the scope of practice of family law. That's a fact. Harris is she works for the North Las Vegas Justice Court. She is a criminal civil, like, no, she's a criminal judge. She does traffic and evictions. Okay, when does she start doing family law? She's fraud. And I can even do a video about Harris where she fraudulently said that the policy enforcers in Las Vegas beat her up. And it's all on video that she never got beat up. She had a fraudulent lawsuit against Las Vegas Metropolitan. I did the dossier on all of them. Like, I know everything about them. And she's fraud. Again, we can get into that in another video. I'll just keep reading for now. Defendant is in violation of fraud and impersonating a family court judge. Page 9. Stephanie A. Charter was then transferred as the new judge of the case. They kept trying to transfer new magistrates and acting as judges to, try to keep me all confused. It's like a mental warfare. But they're all parties to the matter and they're all being sued. Okay. And they all was put warranted. They all was put on notice. Like every time they switched over a new acting as magistrate, I put them on notice. Okay. Defendant was very aware of the unlawful and unwarranted seizure of the child and had a duty, once again, a duty. She had a duty. She took an oath. She has a duty and fundamental interest to stop human trafficking. Stephen B. Wolfson, Stephanie Richard, Beth Rosenblum, Nick Pettis, and Paya Patel was assigned to the case, all acting as attorneys, bringing the case forth to a judge. Without any firsthand knowledge or witness testimony of child abuse or neglect, all parties decided to move forward and unlawfully proceed. Petitioner also placed all defendants on notice in regards to her legal status and the lack of jurisdiction. Please see attachments. Defendants have deliberately placed the child in a position of danger as an emergency medical treatment was requested and granted for treatments unknown to natural mother. Let me stop there. So TPR hearing 11/4/12/22. They had some type of emergency medical procedure on my baby. Again, when my baby was my care, she never even had a comment. I don't get sick again. I've never even been sick in like over 5 years. Like my whole pregnancy, I never even threw up. Not even one time. I never even threw up. I don't get colds. I don't get COVID. Like I don't. I'm a herbalist. Like I eat very well. I work out all the time. I'm a personal trainer. Like I don't get sick. I don't even believe in sickness. Sickness does not exist. With that being said, they did an emergency procedure on my baby, and clearly I had already wrote them an affidavit beforehand that Ashe had been, you know, she was at risk of injury with Sarah. I had it filed and everything. I sent the affidavit saying, hey, I know that my child is with Sarah Da Lue and she is in danger. She's in danger with this lady. Like this lady has her in danger. I don't know how this lady works for a high school and she has my baby, but my baby's in danger. And I told them that. And then lo and behold, months later, they have to have an emergency medical procedure. Like, make it make sense, guys. Again, all defendants failed to list any specific injuries that child may have suffered or potentially may. They all knowingly interfered with the parent-child relationship. In the area of child abuse, as with the investigation and prosecution of all crimes, state actors are constrained by the substantive and procedural guarantees of the Constitution. All right. Count one, assault against defendants Eason and Garcia. Defendant Eason, Garcia, Guerrero, and Anderson assaulted petitioner by unlawfully injuring her as she was sexually harassed and stalked by the defendants with a parent. Go to the next page. Present ability to effectuate the injury under circumstances creating fear and imminent peril when they molested and sexually harassed the petitioner. Count two, battery against defendants Eason, Garcia, Guerrero, Anderson. Defendants Anderson and Guerrero battered petitioner by intentionally and offensively contacting petitioner's body slash property and child Ashe when Anderson and Guerrero took off the clothes of petitioner and Anderson removed the diaper from the baby with sexual intentions and kidnapped petitioner without the requisite level of suspicion. Count three, false imprisonment against defendant Anderson and Guerrero. Defendants Anderson and Guerrero falsely imprisoned plaintiff by unlawfully detaining her against her will. His. I go both ways. Defendant Guerrero had no reason to detain or search petitioner because he did not reasonably believe that petitioner had committed an offense, and there was no proof of probable cause. Defendant Guerrero participated in the unlawful detention. Count four, 42 USC 1983 against all defendants, again, including Sarah and Donella Rowe. Petitioner damages under 42 USC and 1983 for the injuries set forth above all defendants are guilty for violation of her constitutional rights under color of law. Additionally, it was the policy and or custom of the Las Vegas Police Department that failed to exercise reasonable care in hiring its police officers, including defendants Anderson and Guerrero, thereby failing to adequately prevent constitutional violations on the part of its police officers, policy enforcers. Uh-oh. Why do you look like that? Anyways, it was a policy and or custom of the Child Family Services to adequately supervise and train its employees, actors, and agents. They were to be trained as well with constitutional and treaty rights. As a result of the above described policies and customs, policy policy agents of the Las Vegas district and the Las Vegas district attorneys believe that their actions would be justified without proper firsthand knowledge and investigation. Due to their lackluster, again, they're the ones who pretty much set off the unfortunate events. No one has immunity. They're all liable. And I'm going to stop there for now. But again, I will be back with another video and another update. I'll keep you guys posted. And thank you for tuning in. Please like, share, subscribe. I feel like it's something else I want to say. But again, I'll just get back to you guys in my next video. That's it for now. Free baby Ashe. Ashe will be home soon. Energy, energy, energy. Peace and love. Islam.